My lord, I need some accommodation, my lord. I have 3 matters before this honorable court, my lord. Item 1, 4, and 14. I'll do it, my lord, in second half, my lord. I have some problem, my lord, in the first half.
Okay, 1,
1, 4, and 14.
14 supplement. 14 is the IA is for in a review petition.
Yes, my lord. Okay, my lord. Lordship wants to hear the entire matter. I'll do it, my lord, in second half.
My lord, I have a prayer in item number 12, my lord. My lord, I have some difficulties in the evening, my lord. If it is possible to be taken at 2 p.m., my lord, I'll be grateful to your lordship, my lord. 2 p.m., my lord, item 12, my lord.
Okay.
Well,
Deep development.
May it please, your lordship, I beg to mention item number 11 for upgrade, lordship. Lordship, kindly upgrade the matter, take the matter at
11. We have only few matters today. 3 or 4 matters are being adjourned. We'll take it up otherwise also.
upgrade.
11.
Item 11.
Okay. We'll take it up. Don't worry. We come now only.
Lordships, I beg to mention item number 5, 6, and 9. The engaged counsel, Mr. Vadud, is out of station today, and we have taken consent from the other side for the same.
5, 6, and 9.
Yes.
Which is a representative of the parent well and father. Matters is adjourned today. Leave that after.
We-
Also 90 matters. Give a date after vacation. Start vacation.
9th of January.
Obliged, Your Lord.
In item 10 also there is an adjournment step.
Lord.
Item 10 also there is an adjournment step. Item 10. None appears on file to the petitioner. However, advance adjournment slip has been circulated on behalf of the petitioner. All the respondents are represented. Matters is adjourned today. This one.
Supplementary item 13 for admission.
Mayor, please, lordship. I am only an advocate, my lord, in the left side, my lord. Other is,
That is
I am lucky, my lord.
that there's only one celebrity who is alone. That is Bruce Willis, last man standing.
My lord, in this case, my lord, as per inquiry report, my lord, 1166 to 1971, my lord. And in this case, I am relying 3 or 4 judgment, my lord.
Yes.
My lord, Santosh Das, my lord. And next, my lord, I am providing my lord, Sonakha, Golapi Begum, Sushil Mandal, my lord. I am proper.
Given yesterday that Dave was given. Santosh Das.
Yes. Santosh Das, 2017 to GLT 1065.
Yes.
And next, my lord, Sonakha, a WPC number 1293 2021, a
Yes.
date of judgment 24/3/2021.
What is the writ petition number?
WPC number 1293.
1293.
Yes, 2021. Sonakha. A date of judgment, my lord, 24/3/2021.
Okay.
And next, my lord, Golapi Begum, relying, my lord,
Spelling?
Golapi Begum, WPC,
Spelling of Golapi.
GOLAPI.
P for Punjab.
Yes,
Golapi Begum.
Begum, BEGUM.
Yes.
24/3/4/2021. 2020. Date of judgment, my lord, 15/7/2021.
Yes.
And my lord, one more order, my lord, Sushil Mondal. SUSSHIL, Sushil Mondal,
Yes.
a WPC number 87/2019.
Yes.
A date of judgment, my lord, 27/10/2021.
Yes. Yes.
Impugn order is page 60. Here is also mentioned in the paragraph 1, my lord, 1166 to 25/3/1971. And as per inquiry report, page 47. Forty-four onwards, my lord, as per SP order of SP.
Yes.
Page 44, my lord. This is the dated 29/2004. A letter issued by that SPB Morigao, directed the Montu Bordoloi to conduct the inquiry, my lord.
Yes.
In the inquiry, in the page 44, my lord, it has been learned that the Mukles Ali, aged about 45 years, son of so-and-so, village Mukirbeta, district so-and-so, is suspected to be foreign national who entered into India after 1166, my lord. You are therefore directed to start an inquiry under the provision so-and-so, so-and-so. And next page, my lord, page 47, bottom, serial number 1847. In this report, inquiry officer would make effect mark of these findings whether the suspect is the so-and-so foreigner. During inquiry, it appears to me that in prima facie manner that the suspect who entered into India in 1966 to 1977 is student. 71 is. My simple parallel petitioner may be allowed to register his name as per rule 19 of the citizenship union. সোমবারে আসবেন, সোমবারে ক্লাস আছে। সোমবারে আমি ভালোই সব করতে হবে। হোটেল আপনার নাম আছে তো আসলে মাঘ বাপে
Mr. Sharma, in view of this, Rukia Begum, matter has to go back to the tribunal to take a decision. Because the Citizenship Act defines the contours of the citizen. Foreigners Act 2(1). That Rukia Begum, paragraph 21. Page This does not have a stream. Notice does not give a stream. But the reference has a stream. Therefore, the judgment of Santosh Das, which he is citing, says that the what you call the jurisdiction is vested on the basis of the reference made. The reference is 66 to 71. If it is 66 to 71, then why 6A2 of the Citizenship Act will not apply? That is the reason in Rukia Begum it has been sent back. No, but you can't read this entirely without 21. You can't read this in isolation, C21 and 22. Demanded because of this 21 placed on the law. By implication, it applies. You'll have to apply the fine. The Citizenship Act would include 6 to 6A to B. This has to be decided by the tribunal. Heard. So AM or AM Ahmed will counsel for the petitioner. And the responsible. Next. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 27/6/2018, page 60. Asked by so and so in so and so, thereby declaring the petition to be a foreigner. Who has illegally entered into the Indian territory after 25/3/1971. And therefore declared foreigner under section 2 within bracket A of the Foreigners Act 1946. Next para. The petitioner, upon receipt of the notice of the proceedings appeared before the learned tribunal and where is your written statement? Written statement of defense. Inter alia, claiming that the name of the petitioner number 2 no, name of his deceased father was enlisted in the voters list of 1966 of 84 number Lahari Ghat LAC, LAHARIGH LAC in village Behuguri, PEHUGURI under Lahari Ghat police station in the district of Nagaon. And the name and his, we just say 1966 and 1970. The name of the petitioner was enlisted in the voters list of 1985 and 2005 under 84 number Watadrova, BATA, DRAVA, LAC. Of the same village. Also claimed that the father of the petitioner had landed property in village Behipuri. According to comment that the petitioner and his father were not foreigners and did not enter India after 25th in 1971 and were Indian citizens. Next. In support of his defense, the petitioner had examined himself as DW1. So he had stated that one of the opposite parties in the proceedings was Abdul Majid, ABDUL, MSZID, Majid, his father, who has expired about 10 years back. He had stated that he did not attend school and his father casted vote in 1966 and 1970 and he had submitted land documents, and he has casted his vote first in 1985, and thereafter is casting vote regularly. He had exhibited the voters list of 1966 of Abdul Majid, within bracket Exhibit A, Jawabandi copy of containing name of the grandfather, within bracket Exhibit B, Jawabandi copy of his projected father, within bracket Exhibit C, Gaon Panchayat certificate, within bracket Exhibit D, and Gaon certificate, within bracket Exhibit E. He had, in his cross-examination, he had stated that his father expired 10 years back, and he was born and brought up in Behuguri, Behuguri. He has 5 brothers, namely, take it from 53, page 53. His father hailed from Behuguri, and his grandfather's name is Abdul Rahman, Abdul Rahman. His mother is Jamina, Jamena, Khatun, Khatun, who's alive and living. With him, he has 3 paternal uncles, Miasan, Miason, Alisan, Alison. Number 3, and give dot 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 within bracket eligible. Within bracket eligible and not reproduced in the certified copy. Okay. It stated that Miasan has Miason. Miasan has one son Zakir Hussain, and Alisan Alisun has 3 sons. Gofur, Gofur, Manas Mannes, and Kasrem, Kasrem, were all settled in Behuguri. No further witnesses were examined. Next, the learned tribunal, on appreciating the readings and evidence on record, Even with pocket book. But you should consider an award from your team for this tribunal officers. There must be some award every year, exemplary awards, the tribunals. This is exhibit E. Come to page 61 of the writ petition. Para 2. Interestingly, O.P. Muklesh Ali alias so and so named his father as Abdul Mozid, M-O-Z-I-D, huh? That in the WS, but the school certificate exhibited exhibit E. Now look at the certificate in the original. No, no. What is the certificate? This is school certificate.
Oh, no.
Then,
Certificate.
then a Gram Panchayat certificate is written in the opinion as school certificate. He is entitled to some award. You see, who is a good man? Who makes you smile? Mr. Sharma, am I wrong? Anybody who will make us smile is a good man. You know, Charlie Chaplin, Lauren Hardy, all made us smile. Follow Tom and Jerry.
Nine.
There is no school certificate.
No, he tells in his evidence that he did not go to school.
Oh.
And in that same page, no, you can return that. No, in that page 61,
Yes.
come to page 60. See, exhibit E, Gambura certificate. And this is Gaon Panchayat certificate.
It is job on sir, written, explain the school certificate.
So, Mularka, you are here in the foreigners bench. You have to demonstrate that you are Indian or a foreigner. Here, there is only one question.
But it is difficult for some persons to demonstrate that they are Indians.
Hmm.
It is difficult for some persons to demonstrate that they are not Indian.
You're not Indians.
Because if we take the entire population of the country, then there will be only very few people.
Otherwise, Lordship, my humble submission is that, and that stream part tribunal will not be confined within which stream. After the decision of the tribunal, Lordship, opinion of the tribunal, Lordship, it will be
No, it will
affirmed
depend on
that-
what they understand about it. The law is laid down. We are not saying what to do.
Yes, yes.
We're just showing them the law and asking them to do what was done in the case of Rukia Begum.
Yes, yes.
We're just laying down the law and then sending it back.
Okay.
First is Ah. Take note of the evidence on record stating that in Exhibit A, the voters list of 1966, the name of the voter is A. Mustaf Muzid, M-O-Z-I-D, son of Rahman. And there is no other voter list of A. Mustaf Muzid, though he expired only 10 years back. Comma. It was observed that the name of Jamina Khatun, whom the petitioner named as his mother, did not surface anywhere. Similarly, his 5 projected brothers. Therefore, and brothers, so as to establish a clear relationship between the petitioner and his projected father, his name appears in the voters list of 1966. It is next para. It is noticed that while appreciating Exhibit E, the Learned Tribunal has committed a blunder. Although the document exhibited as Exhibit E is a Gram Panchayat certificate issued on 11/6/2015, certifying that Mokalesh, Mokalesh, next per Uddin, UDDIN, son of Abdul ABDUL, Majid MAJIT, is an inhabitant of village BHEHAGURI, which is rendered inadmissible in view of usage of the state emblem of Pillar of Asoka, ASOK. But in paragraph 3 of the opinion, Exhibit E is referred to as Gambura certificate. And in para 4 within bracket Roman 2, Exhibit E is referred to as school certificate. In paragraph 3 of the opinion, exhibit D is referred to as Gaon Panchayat certificate. Whereas the exhibited doc in the records, the document exhibited as D is check. Identity card. Is the identity card issued by the government Gaungura. Therefore, it appears that in paragraph 3, the exhibit D and E are interchanged. Full stop. Be that as it may, as the as the contents of the exhibit D and E refer to the father of the petitioner as Abdul Mozid, MO ZIT. And no, first will be name is referred to as A full stop Majid, MAJIT in exhibit D, and Abdul ABDUL Majid MAJIT in exhibit E, comma, it was held that Abdul Mozid ABDUL Abdul Mozid MOZID appearing in the 1966 voter list within bracket exhibit A is a totally different person. In paragraph 4 within bracket 3, the learned tribunal has referred to 3 documents marked as 1, 2, and 3. But the said document having not been exhibited. This court would not make any comment on the contents of the said documents, which are unexhibited documents. First off, the learned tribunal observed that as the petitioner could not establish that A. Mozid, MOZID, appearing in the voters list of 1966 is his own biological father, comma, the land document exhibited as exhibit B and C did not be discussed. Also, as the land documents are not proved in accordance with Not. However, on a perusal of the contents of exhibit B, which is the copy of Janabandi of the year 1931. The same contains the name of Rahman Sheikh. Son of Halim. Son of Halim. Mr. Ahmed,
My lord.
while we are passing the order, we think you have not been able to make out a case.
My lord, he has exhibited voter list of 1985, my lord, where his father name and mother name is appear.
Everything is goes now. Everything goes. Stop, however, comma, in his cross-examination, the DW1 had stated stated that the name of his grandfather is Abdul Rahman. So therefore, comma, the name Abdul Rahman does not match with the contents of exhibit B, with the name of the person who in whose name the land is mutated is Rahman Sheikh. So exhibit C contains the name of A. Majid, M.A.J.I.D. Let me change. This paragraph will go elsewhere. Last paragraph will go elsewhere. Just make a note, goes below. Huh? You see, it was not considered. Stop there. Not considered. Stop. Accordingly, comma. The learned tribunal held the petitioner, namely Muhammad Mukhlesh Ali alias Mukhleshuddin, as well as his father Abdul Mazid alias A. Mozid, M-O-Z-I-T, as foreigners. Mr. Ahmed,
My lord.
it leads to another issue. Your father died
10 years
10 years back.
back, as per.
Still, the tribunal declares your father to be a foreigner, which could have been done.
Actually,
And that part of the order is not under challenge. Because you say that you have other brothers and sisters. And nobody has joined to challenge the opinion of your father. If your father is a foreigner, there's no challenge here. We have no alternative but dismiss your.
my lord, tribunal ought to not have declared the father as a.
Why not?
But he is the died person. my lord.
Yes, still it can be done.
Yes,
There's no bar.
that is
Because
the wrong
once
done
he
by the
declared-
tribunal.
Once he's declared to be a foreigner, then all his sons and daughters, whoever is taking his lineage will be affected. This is not a civil decree which makes a declaration bad. Having passed against a dead man.
That and that part kept open to the petitioner to challenge that
But
part.
then it will be dismissed here right now. Because your father, your grandfather is not the name which you are saying. It has been, exhibit 2, it is different. Once it is different,
Voter list 1966, my lord.
what is the 1960, you must connect A with B. Something
Abdul
like in-
Mujid.
Something
A
like in
Mujid.
school, we have a scale, we put 2 dots, and then with using a scale, we connect them.
Voter list
Sitting here.
1966, my lord. Here is Abdul Mujid, A Mujid, my lord. A means, my lord. We have
Whatever
always
be.
used as Abdul.
No,
Abdul.
whatever be, but he's your father, please show that.
Yes, in the voter list of 1985.
85,
Exhibited.
you see. Here again, there is a difference. This is Mujid, top.
That is,
We don't know about it.
yes,
We don't know about it because otherwise the documents don't match.
Mujid, my lord.
There's no explanation. The composition certificate is Mujid. Doesn't say that the father was wrongly written here.
Sometimes.
The explanatory notes come from your document 1, 2, and 3, and that was not proved. Because you have a mother alive, she did not come to give evidence. You say that you had siblings, you had uncles, nobody came. Therefore, to connect you to your projected father,
In that part, actually, my lord,
it's just not there.
some part fault of the petitioner also, my lord, learned council in this.
Ahmed, you are not being able to connect. The Gamra certificate goes because it has the state emblem, the other document. You see, once there's a doubt created, then this doubt can travel anywhere. You see, your exhibit B is a land document of 1931, 3031. There's a name, Rahman Sheikh. Now you see, this land is 53 bigha, 2 kathai 11 lacha. If you have this plot of land, it is unbelievable that you would not mutate the land in the name from your grandfather to your father and from your father to the children. 53 bigha is something which is not left alone like that. There is a second land of the last mutation is of 87. Okay, this land is 2 bigha 1 kata 10 lacha. Here also you don't take steps to mutate the same from the name of your deceased father. Only with the doubt, you can only think that you may not be the son and therefore your names are not there and therefore you are not producing the current Jamabandi.
In the one Seldit Miller, page 24,
Shelled is not an exhibited document.
yes, here is Abdul Mujid, son of Abdul Rahman, and Banakular also Miller, page 26, bottom.
Those are not exhibited documents.
Mm. And page 19 Miller, Banakular, Hafizuddin Obhibabok Abdul Rahman,
No, but if you have this.
page
document
19 Miller,
you
that is
exhibited,
exhibited document.
why these were not exhibited?
Page 19 Miller, that is exhibited C. Page 19 Miller.
19 years, that's why we have said 87. We told you 87, you see, come to the remark column. Last mutation is 87,
Yes,
2 bigha 1 kata 9 lisha.
yes, Dubga
That's why I
Kata.
said, father is died and no steps have been taken to bring it in your names. When you make us read things, we have seen this exhibit 3, annexure 3, Chitta of 57, 58. Here also you see the first name is
Ismail Sheikh,
Ismail Sheikh.
Saif Ali, and Abdul
So-
Hamid, Abdul Mujid, Abdul Barik, son of Abdul Rahman. Page 22.
Correct. So this Abdul Rahman is not the owner of the land. Whereas in the earlier Jamabandi, you have this this Rahman Sheikh as the owner of land.
Abdul Mujid, Abdul Barik, son of Abdul Rahman.
See, there must be some connect. Here the father is Abdul Rahman. In Jamabandi, there is Rahman Sheikh.
That part written by the authority member, land document
No,
authority.
they don't write anything from themselves. Somebody must apply.
Yes, sir.
Mutation is not done like that. Somebody orally claims.
Here is also page 19 Milot, Obhibabok only Rahman. Page 19 Milot, bottom. Abdul Mujid, Obhibabok only
You
Rahman.
see this,
That was done by the authority member.
I don't know. But few experience we have with this mutation, I've never seen an oral mutation. Perhaps I appeared for small, what you call little men. You have an experience of appearing for big people. Oral mutation you have seen, I have not seen that. You have to apply. I thought this must be dictated in the chambers. You apply the fresh mind. We'll apply fresh mind. Now the mind is too clogged.
Yes.
To think independently. Rest of the orders will pass in chambers.
Bless.
But on a lighter note, my name appears in there now,
Bless.
including my family.
Good.
And we,
No, at least,
at least, and
no,
this holds good for the entire country because this is the only state where we have that answer.
no. It is good because we are taking a foreigner's bench. It is good that we know that. Mr. Sharma will take note of it.
That process was very cumbersome. Not easy because I had appeared for two organizations, including Assam Sahitya Sabha, where people of Indian origin, even from Assam and from other states, they were asked to show documents before 67 from Assam only. So we challenged that. We said, if I am a person of Indian origin, I can show document from any part of the country, of my parents, showing their lineage and all. My name should be included. And that happened. A lot of people got benefit of. Because there may be some people who came after 67, have been staying here. But their sisters are from maybe UP, Rajasthan, Tamil Nadu, whatever. That was allowed. A lot of people. got benefit of.
Yes.
Item 2 for hearing.
None appears on call for the petitioner. All the respondents are represented. For injustice, justice, the matter stands adjourned today. It is made clear that if the petitioner remains absent, I'm represented on the next date of listing, my adverse orders would follow. Those the 19, give a date, fixed date, we stop.
Item 3 for hearing.
Three. Same order, none appears on call for the petitioner. Yes.
Item 7 for hearing.
Item 7. Same order, item 7. Same order.
Item 8 for hearing.
Yes, Mr. Rawat.
Yeah, Lordship,
Yes.
for getting instruction, I want something. I am not getting any instruction, so I want something.
You want some time?
Yeah, Lordship.
Okay. On the prayer made by Mr. U.C. Ravan and counsel for the petitioner, the matter stands adjourned to enable him to obtain instructions. All the respondents are represented. List on same date. 22 January.
But myself.
Item 11.
Small notes. Well, this is for compensation of a person, my lord, whose husband died. My lord, I have given a list of dates chronologically. Huh? That list is there. He was picked up by the police, my lord. Then his body was found. Charge sheet against all the persons, police officials. That your lordship will get it at page 55 onwards. And page 91, your lordship may kindly see page 91. Very high-handed action on the part of the police official. Page 91 to 96, these are the facts. Paragraph page 97, page 95, 17.9. Seven point nine, 17.9. So lordship allows me, I can read this. 17.9. All these officials are involved. Charge sheet will show that all the police officials are involved in the killing of the petitioner's husband, who was 38 years. The government has appointed a special public prosecutor also. Charges have been framed. No. Public prosecutor appointment court. That is WPCP. Yeah, WPCP. The question you. Yes. Hello, I'm just giving a copy of the order of the court, showing that at the instance of the petitioner, a repetition was filed. Public prosecutor was appointed by the government for conducting it. I'm just pointing out, bringing the facts. So if your lordship looks into the charge sheet, your lordship will find that the police officials, if he was killed by at the hands of the police officials, and charge sheet has been framed and things are going on. Now, only for the purpose of compensation, I would like to submit, my lord. At the time when he was picked up, my lord, he was the owner of the 4 vehicles. This will be relevant for the purpose of calculation of the compensation. Your lordship will get it at page 27. 27 series, to the owner of 4 vehicles. And page. Family consists of the petitioner, the wife, 2 minor daughters, and 1 minor son. That your lordship get it at paragraph 13. Page 36. 2 daughters, minor daughters, and 1 minor son. Page 36, if your lordship allows me to read. Because, yes, and the victim was 38 years.
at the time of his kidnapping. Now, page 119 to 128, his loan statement in bank is shown. His monthly installment was 3,59,590. 3,59,590 towards installment. And other 59,590. 590. And his, at the time of his death, his liability was 95,65,830. Lakhs 65,830. Paragraph page 119, if you also look into. These are the bank statements. And your lordship will get it, his installment dues, page 119. Statement of account. Indus Bank. Your lordship will get it below, my lord. His loan amount, finance amount is right hand side. 6,33,000. Santosh Uday, your lordship will get it at the top. Contract date is 26/7/19. Bolero, car right hand side. And installment amount below, your lordship will get it column 4. And he has been paying the installments. The second vehicle loan, your lordship will get it at 121. Loan amount, right hand column. Finance amount, 19,90,000. And his installment was 63,150. Next is page 123, man. Installment amount is, your lordship will get it below, my lord. Below, left hand side, installment 1. Yes. Installment, your lordship got it. 31st is page 119 is 34,300. Then second for the second, similarly 63,150 for the second vehicle. JCB backhoe loader. Loan amount is 19 lakhs, finance amount, and installment amount is 63 lakhs 150. Similarly, at page 123, product model is there. Loan amount is 16 lakhs 90,000. Installment amount is 56 lakhs 56,150. Similarly, at page 125, your lordship will get finance amount. I can make a concise second. Product name is there. Finance amount is 22 lakhs 40,000, page 125. And installment is 67,990. And page 127, product is excavator. He took a loan of 39 lakhs. And he was paying installment of rupees 1,38,000. Here. Here, that's it. I'm just pointing out the documents here. Nobody is denied this. So now the law is very clear. If you have the name of the family, age of the persons, and the income of the persons, my lord, then the amount of compensation can be calculated. My lord, to point out that, my lord, I can straightway come to my lord, the Supreme Court judgment recently given. My lord, Sanjay Gupta case. Or we have placed it, my lord. I can point out also a Madras case. My lord, if your lordship looks into it before coming to the Supreme Court judgment. Madras High Court. Before that, I will point out this Madras High Court judgment. This is for custodial torture resulting in the death. A PIL was filed. Paragraph 1, 3, 4, 15. Paragraph 1, 3, 4, 15, 16. 18. 17, 18, 21, 26. 27. Hello. There is paragraph 26. 28. 28, your lordship will get it. In paragraph 17, your lordship will get paragraph 16 also, the sub paragraph. 16, 17. 16 and 27. Then paragraph 28, your lordship will get it paragraph 11. Sub paragraph. Then 29, para 30, 31. Ultimately, compensation determined at paragraph 74, 75, 76, and 70. This is a custodial torture case, my lord, where custodial torture case, my lord, where a 35 years painter was picked up and he was tortured. Ultimately, he met the fate of death. He's a fitter man. May I read, my lord, if lordship wants to? Facts, your lordship will start at paragraph. It's a very detailed judgment. And I was before Sanjay Gupta case. Sanjay Gupta has made it clear that in case of that in the custody, my lord, that Sarla Verma case will be applicable. MSC2 case for the purpose of compensation. May I read para 1 now? Claiming him to himself to be a co-convener of campaign for custodial justice and abolition of torture, petitioner has filed the instant public interest litigation seeking a writ of mandamus to direct respondents to pay compensation of rupees 20 lakhs, but ultimately was paid more on the basis of the calculation of Sarla Verma. Namely, so and so wife 28 years, daughters 9 years, Nirashini 6 years, Sona 4 years, and so 3 years. As the disease was taken to illegal custody on midnight of 28/5/15, detained illegally and was inflicted with grave injuries by ninth respondent and his team for 7 days, and the disease succumbed to the injuries. The 12th respondent hospital on to 6/6/15. This is the facts in short, my lord, in brief. Paragraph 3, your lordship will kindly see the action of the police. Petitioner has further submitted that E. Subramaniam Sanso, so aged 35 years at the time of death, was survived by his wife, named so and so, son and daughters. A police team, including the 9th respondent, took the disease from his house to inquire him in relation to murder of one Mumtaz. The 9th respondent and his team illegally detained Subramaniam for a week and tortured him, and ultimately he died in the hospital due to injuries caused by the 9th and 11th respondent. And paragraph 15, your lordship will find, and judicial magistrate submitted a report. Paragraph 15. Mali. Hello, dear lordship, may kindly see paragraph 50. Hello. One forward. So many sub-paragraphs are there, my lord.
1/5 is in which page? Which page?
Page 13, I think.
1/3.
Yes.
Wait, here, page.
May I read?
Yes.
Initially, a case in crime has been registered under under section 174. Subsequently, the claim has been altered to 176. After conducting a judicial inquiry, learned judicial magistrate so and so has submitted a report on so and so before the learned chief judicial magistrate. So and so prima facie finding that the deceased Mr. So and so was beaten up by Inspector Mr. Raja, then working in so and so police station, and other charge sheet to have been filed under section 218 so and so, and the case is stated to be pending trial dated so and so. From the above, it could be deducted that there is a specific finding of torture and injuries caused to the deceased Mr. so and so. Copy of the report and etc. My point is that the judicial magistrate inquiry has found that he was tortured, ultimately which resulted in to death. Paragraph 16, your lordship will just kindly note regarding the compensation. When the matter came up on 7/8/19, Mr. So-and-so learned additional government pleader appearing for the official respondent submitted that if this court deems it fit to consider that the state is bound to compensate the family of the deceased Subramaniam who died in custody, then the quantum of compensation be restricted to rupees 5 lakhs as done in the order made in WPC number so and so. He further submitted that if quantum of compensation payable by the state is determined by this court, then the right to recover from the accused be given to the state. This was the submissions of the respondents. Then your lordship will kindly see paragraph 18. No, not paragraph 18, paragraph 26, page 28. Paragraph, page 26, 28.
Page 28.
Yes, paragraph 26. On the above pleadings and submissions, so he was tortured, he died, and my lord, judicial inquiry also finds that he was tortured and the trial was going on. Similarly, in this case also, custodial death is proved in a charge sheet has been filed and the trial is going. This is also the same case. Here the things are much more. The way the petitioner husband was treated. Paragraph 26, page 28. May I read?
Page number
28, paragraph 26.
26, yes.
Yes. On the above pleadings and submissions, the following points are framed for consideration. Whether a public interest litigation is maintainable for claiming compensation in a matter of illegal custody, custodial death, torture, and such other heinous offences. Whether when the affected party has a remedy to approach the civil court, and whether a public law remedy is a bar. In the absence of any method of calculation to arrive at the compensation, whether writ court can adopt the multiplier method as applied in compensating accidents victims under the Motor Vehicle Act. Whether the victims or legal representatives of the victim can claim compensation by way of institutions of a suit or other proceedings claiming compensation other than what is awarded in a proceedings under Article 226 of the Constitution. Now, so many cases have been discussed. I'll take your lordship straight to paragraph 61. Page 121. I think. Page 121. Others are all my cases have been discussed.
121.
121. Paragraph 61. 266 I'll rely upon. 67 also. May I read, madam?
Yes.
Paragraph 61. On the aspect that in the absence of any method to arrive at compensation to the victim, where the multiplier method followed in the case of accident claims, victims can be applied for compensating victims of the custodial violence, death, or other offences. The Honorable Supreme Court in the various decisions held that the compensation ordered in writ proceedings under 226 of the Constitution, as the case may be, would not disable the victims from claiming compensation under private law remedy. Any such compensation awarded by the Honorable Supreme Court or High Court, as the case may be, is less than what the victims or legal representatives are entitled to under private law remedy. The Honorable Supreme Court has also observed that what is awarded by the courts under Article 32 and 226 of the Constitution of India, as the case may be given credit to. Reference can be made to the decisions DK Bose and West Bengal so and Nilavati Behra case, relied on by the learned additional Advocate General. The Honorable Supreme Court in various decisions quoted Supra has also made it clear that objection to the maintainability of the writ petition is technical. Now, paragraph 63, my lord. Honorable Appeals Court has also observed that there is no need to relegate the litigant to approach the civil court for compensation. The Honorable Supreme Court has also given the liberty to the victim to approach the civil court if the compensation awarded in the writ proceeding is not adequate. Compensation to be awarded should be just and reasonable. What applies to the victims of the motor accident cases in the matter of awarding compensation, namely just compensation, can be awarded in cases of the custodial violence that or other cognizance offences. When the state cannot claim sovereign immunity in the matter of custodial death or violence and other offences and deny the payment of compensation under the public law remedy, application of the method of compensation accidents and compensating accident victims can be safely applied in cases on custodial violence, torture, and death also. The Honorable Supreme Court in so and so, it is clear that method adopted in compensating accidents victims can be taken as a guide in the matter of compensating victims of the custodial violence and death also. In the light of the above discussions and decisions, we are of the view that computations of the compensation as done in compensating accident victims can be applied in cases relating to custodial death or violence, etc. Malab, subsequently, the Supreme Court decision has also come into thing in the Sanjay Gupta case, so I'm not reading everything. 67, my lord. Though Monomoron submitted that the quantum of compensation can be restricted to rupees 5 lakhs only, and that the principle applied for determining the compensation under the motor accident need not be followed. We are not inclined to exceed the said compensation for the reasons that in case of death in custody or in electrocutions or any other act involving negligence or offense, there is no prescribed method under the enactment for computing the compensation. But the compensation to be determined by the court should be just compensation. At this juncture, it is also useful to refer the meaning of the word compensation. The word compensation has been defined, so and so, all these things are there. Ultimately, paragraph 72, madam. 160. The division bench judgment, the Madras High Court. Paragraph 72, madam.
Page 160.
For page 160. In National Insurance case versus so and so, the Honorable Supreme Court has partly modified the parameters enunciated in two judges' bench decision in Sarla Verma versus Delhi Transport Corporation reported in so and so, and laid down principles as follows. While determining the income as addition to an addition of 50% of the actual salary to the income of the deceased towards future prospects, where the deceased had a permanent job and was below the age of 40 years should be made. Now, these are the method of calculations that it has been enunciated. Reasonable, the age of the deceased should be the basis. In case the deceased was between 50 to 60 years, the addition should be 15% actual salary should be read as actual salary less tax. In case the deceased was self-employed or on a fixed salary, an addition of 40% of the established income should be the warrant. 72. Paragraph 73. In the case on hand, at the time of death, the deceased was aged 36 years and self-employed as a painter. As stated supra, we determine the income at rupees 378 per day, that apart by so and so, published in Tamil Nadu Government Gazette notification dated so and so, besides awarding minimum rates of wages, the DNH allowance for the period from so and so to so and so shall be payable at the so and so. Ultimately, it was calculated 27 lakhs was paid. Paragraph 74.
Yes.
All these calculations on the basis of the MSCT case only and the basis of the guidelines. Lordship will kindly see his basic wage was taken into consideration. DA was wages per month, paragraph 74. So this is a division bench judgment. So I'll come to now Supreme Court judgment. What should the matter, let's say Sanjay Gupta case 2022 7 SCC 203. I've given a copy. This is a victim of fire tragedy that occurred in 2006. Are you lost it? 2022 7 SCC 203. Huh? Huh? The them.
Along with note will be there. Along with note.
Along with note, it will be there.
Note will be before we have long.
Earlier we had given.
That's,
As a Lordship got it.
yes,
Well, this is a case of victim of fire tragedy occurred in 2006. And a commission was appointed, then thereafter another commission was appointed.
this is that Ansel Cinema.
Yes, I think so. ma'am. Sanjay
Pahar,
Gupta case,
Pahar.
para 1.
Like,
এটি কোনটা ছিল? A college field was taken on hire, my lord. Then thereafter.
this is
the
Merit
tragedy.
Fire.
Yes,
Yesterday's fire, has it come down? Somebody told me that it's even today morning it was burnt.
it is going on. ma'am. It was going on when I came to office.
Our documents were also there, madam. Our loan documents also there in the bank.
No, bank, they will have server. It
The
is.
bank is, everything is documented.
The,
But
Physical
there is
document may be lost, but.
yes, hard copies were there.
only that the lockers and et cetera, whether it is fireproof or not, will come to know now.
Mr. Goswami is making a false statement in court. How it could be false? People tell us that he gives loan.
But
I
we'll
don't-
come to know whether the lockers are fireproof or not. my lord.
But
Because so many persons.
20 hours continuous, my lord, this fire, certainly, my lord, people.
My lord, paragraph 1 is the, my lord, facts. Victoria Park. Present lead petition has been preferred by the victims of the fire tragedy, which occurred on 2000, in the year 2006. The last date of India Brand Consumer Show organized at Victoria Park, Miro, Uttar Pradesh by Mrinal Events, and expositions who are being represented as respondent number 10 to 12. For the sake of convenience, respondent number 10 to 12 are being collectively referred as organizers. This unfortunate incident claimed the lives of 65 persons and left 161 or more with burn injuries. This is the facts. My lord, ultimately, because the rent was taken, the organizers had to have paid rent. So therefore, court directed that it should be, the district judge was directed to calculate the amount on the basis of survival. I'll straightway, commission's report is there, straightway come to paragraph, my lord, page 13. Page 13, paragraph 14. Paragraph, subparagraph 67 of the Delhi, the Upar Cinema tragedy victims case. Paragraph 67, subparagraph 67, page 13, madam. May I read, madam?
Yes.
Insofar as death cases are concerned, the principle of determining compensation is streamlined by several decisions of this court. See, for example, Sarla Bilba, 2009, so and so. If 3 factors are available, the compensation can be determined. The first is the age of the disease. Here they are 38 years. The second is the income of the disease. Here he was paying about 3 lakh some thousand. And the third is number of dependents. All these things are there. For convenience, the third factor can also be excluded by adopting a standard deductions of 1/3 towards personal expenses. Therefore, just 2 factors are required to be ascertained to determine the compensation in 59 individual cases. First is the annual income of the disease, 2/3 of the, to which becomes the annual loss of dependency. And the second Second, the age of the disease, which will furnish the multiplier in terms of Sarla Varma. The annual loss of dependency multiplied by the multiplier will give the compensation. As this is a comparatively simple exercise, we direct the Registrar General of the Delhi High Court to receive applications in regard to that cases from the claimants who want a compensation in excess of what has been awarded. That is rupees 10 lakhs and rupees 7.5 lakhs. Such applications should be filed within 3 months and so on. Then paragraph, Lordship will kindly see page 114. Page 114 कहाँ है? Page 14 I think मतलब.
14.
Page 14 मतलब. Paragraph 15, subparagraph 96 मतलब. Page 14 मतलब.
Just a moment.
Hello, since the ratio is already there, I don't want to trouble your lordship by reading all the paragraphs. Just for the sake of your lordship's convenience and information, my lord, I'm just reading this. Paragraph that page 40, page 13, my lord, paragraph, subparagraph 16, 67 of paragraph 4. Yeah. Just for your lordship, because ratio is already there, I'm just reading the rationale behind. Insofar as that cases are concerned, the principle of determining compensation is streamlined by several decisions of this court. If three factors are there, I have already read one. First is the annual, available can be determined. The first is the age of disease, the second is the income of the disease, and the third is the number of dependents. To determine the percentage of deductions for personal expenses. For convenience, the third factor can also be excluded by adopting a standard deductions of 1/3 towards personal expenses. You'll also be skip that. Come to page, next page, my lord. Page 14, subparagraph 96 of paragraph 15. This is the rationale behind. May I read one? Is 90, paragraph 90, subparagraph 96. Courts have held that due to action or inaction of the state or its officers, if the fundamental rights of a citizens are infringed, then the liability of the state, its officials and instrumentalities is strict. The claim raised for compensation in such a case is not a private law claim for damages under which the damages recoverable are large. The claim made for compensation in public law is of compensating the claimants for deprivation of life and personal liberty, which has nothing to do with a claim in a private law claim in tort in an ordinary civil court. But paragraph 98, but in a case where the life and personal liberty have been violated and absence of any statutory provisions for compensation in the statute, if is of no consequence, right to life guaranteed under Article 21 of the Constitution of India is the most sacred right preserved and protected under the Constitution, violation of which is always actionable, and there is no necessarily of statutory provisions. Now, next paragraph you also will kindly see, categories wise it is given. Paragraph 16. We find that those are rational behind. We find the precedents for payment of compensation in a writ petition under Article 32 of the Constitution fall under three categories of cases. First category is where the acts of commissions or omissions are attributed to the state or its officers. We fall in this category as Nilavati Behera and so case. The second paragraph 72nd category, a category of cases is where compensation has been awarded against a corporate entity, which is engaged in an activity having the potential to affect the life. Now, paragraph 18, the third category comprises of cases where the liability for payment of compensation has been apportioned between the state and the organizers. So we fall in the first category itself. Then your lordship will kindly see paragraph 98. Page 14, but in a case where life and personal liberty have been violated, the absence of a statutory any provision for compensation in the statute is of no consequence. Right to life guaranteed under Article 21 of the Constitution is the most sacred right preserved and protected under the Constitution, violations of which is always actionable, and there is no necessity of statutory provision as such for preserving that right. Now, your lordship will kindly see page. Ultimately, my lord, the paragraph 27, paragraph 23, my lord, page 16. Page 16. In the present case, the organizers took permission from the college authorities for organizing the exhibitions after payment of rupees 40,000 as license fee. Such exhibition was organized by the same organizer after the success of Build in Style exhibition at Meerut, held on 24, 25, and 26 December 2005, with an object that various brands in the segment of construction materials could get a platform where they could launch or expose their merchandise to a considerable segment or gather information on the prevailing market demographics or even assess and display the acceptability for certain trend. Now, paragraph page 27, your lordship will kindly see. Paragraph 57. Paragraph 27. The state has paid rupees 2 lakhs each as this year compensation to the families of the deceased, rupees 1 lakh each for the persons who suffered serious injuries, and rupees 50,000 each for the persons suffering from minor injuries, whereas the Union of India has paid ex gratia compensation of rupees 1 lakh each for the deceased and rupees 50,000 each for those with serious injuries. In terms of the order of this court, the state has paid rupees 5 lakh each to the deceased, rupees 2 lakhs each to the victims suffering serious injuries, and rupees 75 each to so and so. Here, pilot private compensation was interim compensation of rupees 5 lakh as rupees was provided in this case. So the list, paragraph 58, The list of deceased and injured persons has been produced by the learned counsel for the petitioner. The amount of compensation payable to each of the victims, including the families of the deceased, have not been computed, and as such amount is required to be computed in accordance with the principle of just compensation, as in the case of accident under Motor Vehicle Act by the Motor Accidents Claim Tribunal. 59, my lord, this is the paragraph, my lord, important paragraph ratio. We therefore request the Honorable Chief Justice of Allahabad High Court to entrust the work of determination and compensation to a judicial officer in the rank of district judge at merit within 2 weeks of the order of this court to work exclusively on the questions of determinations of compensation on the day-to-day basis. The High Court shall provide all necessary infrastructure to enable the officer to discharge his duties. The nominated judicial officer may permit the parties to lead such evidence as may be permissible. We hope that the nominated judicial officer shall calculate the amount of compensation and forward the report to this court for consideration in respect of compensation in accordance with law. The amount paid by the state and the sum of rupees 30 lakhs deposited by the organizer has been disbursed. It was directed to be paid in terms of the Sarla Verma case. 58. That page 14, that paragraph 14, page 27, paragraph 58. Under the MSCT case. As your lordship, this is the principal rate, and your lordship will kindly see flag B. Flag B of the Madras single judge judgment. On the basis of the Sanjay Gupta case. Paragraph 1, 6, 7, 8, 10. Flag B, madam. This is a single judge, it doesn't be persuasive. It is based on Sanjay Gupta's case. I think B, madam. Two, sorry, madam, 2. Like 2, as your lordship got it now. Para 1. Order, my lord, at para 2, my lord. According to the petitioner, she is the mother of the deceased, namely so and so. At the time of occurrence, her son was 17 years old. The said deceased was working as a cleaner in art mover vehicle. Earlier on so and so, one Kalyan Sundaram gave a complaint alleging that some jewels were stolen from his house. In this connection, the police officer attached to the so-and-so colony stations have inquired about the theft, and thereafter the police came to their area on 2019 and directed some persons for attending inquiry. Based on police instructions on so-and-so, at about so-and-so, the petitioner and her son, along with others, appeared before the inspector of police attached to the so-and-so, and the inspector interrogated them. Thereafter, on so-and-so, the petitioner's son went to so-and-so with regard to his work at so-and-so manufacturing factory. Then paragraph 3, your lordship will kindly say, thereafter, at about 7:30 p.m., he was produced before the learned judicial magistrate number so-and-so Madurai for remand. At that time, the learned magistrate has informed the police to produce her son on so-and-so before the Juvenile Justice Board. Thereafter, only the petitioner came to know that crime number so-and-so for the offense under section 387 was registered against her son. On the same day at about 9 p.m., when they reached home along with their son, he could not open his mouth and was struggling to speak and even struggling for normal breathing. Immediately, they have taken him to so-and-so hospital for treatment, and the doctor advised them to admit in the hospital since he sustained multiple injuries and was having severe fever. At that time, her son told that one inspector of police, sub-inspector of police so-and-so, and one Ravi, and another one police Ravi had taken him and they assaulted, and thereby he sustained injuries. Further, her son was under illegal custody from so-and-so 2019, January 19 to 16/1/2019, and the doctor of so-and-so specifically informed that her son's kidney was damaged. Therefore, her son was shifted to government Rajaji Hospital, Madurai for further treatment. So ultimately, my last paragraph, thereafter, and so, then he died in the hospital. Last paragraph, last sentence. Paragraph 4, my lord, a writ petition was filed since the son of the petitioner died due to custodial torture. Paragraph 4. Then contention is there, my lord, paragraph 7. The learned counsel for the petitioner would contend that the son of the petitioner was tortured by the police officials. They have beaten him, thereby he sustained injuries and he was admitted in the hospital, and during treatment he died in the government hospital. Hence she filed a petition seeking compensation of rupees 50 lakhs. Already FIR was registered in crime number so-and-so for the offense under section 174, and thereafter the investigation was entrusted with the CBCID police, and based on their investigation, final report has been filed as against the police officials, and now the case is pending. Now, last year, Lordship will kindly see last sentence, the learned counsel appearing for the petitioner also relied in the judgment of the Honorable, that Sanjay Gupta case. Yeah. Now, government submission, your Lordship will get it at paragraph 8, as usual, my lord. And para 11, my lord, Sanjay Gupta case, we have, the petitioner has. Para 11, my lord, I read, coming to the quantum of compensation, according to the petitioner, her son was working as a bulk line cleaner, and so any document was filed to prove the income of the deceased. No document was filed. However, for deciding the quantum, there is no formula or custodial debt. Therefore, this court safely follows the method adopted in MSCT cases. In this context, the learned counsel appearing for the petitioner also relied on Sanjay Gupta, wherein the Honorable Supreme Court has held the violation of life and personal liberty compensation to the victims to be computed in accordance with principles of just compensation, as in the case of accidents under the Motor Vehicle Act. It is admitted by both the parties that the son of the petitioner was minor, aged 17 years at the time of occurrence. So accordingly, my lord, compensation was paragraph 12. Compensation was calculated. Paragraph 12. And rupees 25 lakhs was paid. Paragraph 14 with 6% increase. My lord, 2 o'clock, my lord, 15 minutes or one matter is listed before some matter. About 2:30 or so, my lord, the lordship permits me. I'll take another judgment, which is of this Madras High Court only. That is at flag 3, my lord.
The finest of them.
Okay. You can say once. Leave.
That you.
Uh,
That you know that the pockets.
Go ahead.
In that case, actually, we should fix it some other day, man.
Yes, I'm completing. No, I'll take only 10 minutes, my lord. I have already did that
because-
like 3. Your lordship has heard the matter. It's very difficult. to-
I think it is part of it.
Yeah, may not be there. Very difficult to get.
This will remain part of in that case.
Bench may not be available. Mala, half an hour your lordship will give.
Otherwise also, well, we have to reply all these things. We have to respond all these.
Their reply is there already in the judgment. my lord.
My lord.
That
Yes.
is it.
All. I have also some problem in the second half. my lord. In my absence, my learned friend will be here. Bora, Sarma, both are dear.
I need only, foreigners matters when nobody is going to any foreign country.
Well, I'll let him complete his part, my lord, then,
I'll take, lordship will kindly accommodate me only for.
and in case, my lord, we have to respond appropriately, certainly. My lord. My lord, that is I want.
No, that's all. We don't want that to be done. Because since after placing all these matters, otherwise, we have placed the matters only that whether what is to be calculated.
Only thing, my
And
lord,
this will be a
my
very
respected
important
senior
decision
has
for-
entered into various areas, my lord, so.
These are all known, my lord, your lordship will kindly see Madras High Court, Supreme Court judgment, whether already placed, the ratio is there.
That time, of course, I was not there.
May I clear your lordship? My lord, already I have submitted in writing. I will take your lordship to page 8. The justification for rehearing. Just, I will just mention a paragraph. This order of the Honorable Court, it was mentioned in this appeal. The appellant has referred to the record of Bongaigaon GRPS UD case number 38 of 2014 dated 16/6/14. And reliance is placed on the seizure list prepared on 16/6/2014 at 1 p.m. by which mention has been made about seizure of a journey ticket from Sautara to Kamaksha Junction 5, ticket number so and so, rupees 65 dated 16/6/14. However, the said seizure as per the statement made in subpara F on the ground for this appeal discloses that the seizure of the journey ticket was made from the brother of the deceased. There is nothing to show that the brother of the deceased, namely
Benu Chandra Sarkar was a co-passenger along with the deceased. Therefore, there is no material appended to this memo of appeal so as to dispel the finding recorded by the learned tribunal in connection with a restoration petition number 5 of 2018, Height order dated 12/11/2018, that the seizure memo was not prepared by the IO deputed for the purpose of investigation who was examined as AW4. My humble submission is that, my lord, the adequate answer to the observation of the honorable court that the railway journey ticket could not be linked up is ex facie evident in the evidence of ASI Robindranath, witness Benu Chandra Sarkar, and witness Jongeshwar Pathak. Witness Benu Chandra Sarkar clearly explained during his cross-examination at page 18 as to how the railway journey ticket of his deceased brother Sanu Sarkar came to his hand. He stated, "We reached hospital at around 12:30 afternoon. Before postmortem was conducted, police personnel handed over a broken mobile handset, display and keyboard removed, some cash and a railway journey ticket to me. Then relevant portion of evidence of ASI Robindranath Ray. The IO of the case deposed, one constable of GRPS Bongaigaon had accompanied the injured person, since deceased, to the Bongaigaon Civil Hospital. I had seen the injured person lying on the other side of the track, that is not on the side of the platform. Before I reached the hospital, relatives of the deceased had already arrived. And the evidence of witness SI Jongeshwar Pathak reaches us. Applicant's counsel during hearing held on 9/3/2018 had filed an application for examination and cross-examination of the official of Bongaigaon GRPS to clarify the doubt of seizure police to set the suitable entry in the case diary. Jongeshwar Pathak has produced the diary in this case, which has been perused in the court. There is an entry made on 16/6/2014 at 1 p.m. of seizure of one journey ticket. So it is obvious that the journey ticket was handed over by the police to Benu Chandra Sarkar prior to conducting the postmortem on his deceased brother, Sanu Sarkar. And that ticket was seized by ASI Robindranath Ray, who arrived at the hospital after arrival of Benu Chandra Sarkar and other family members of the deceased. The above facts are clarified to the fullest extent by the official witness SI Jongeshwar Pathak, who was called to clarify the doubt of the seizure list by checking the suitable entry in the case diary, and the learned tribunal has recorded his evidence in as such. Jongeshwar Pathak has produced the diary in this case, which has been perused in the court. There is an entry made on 16/6/2014 at 1 p.m. of seizure of one journey ticket. The most relevant portions of the evidence of these three witnesses escaped the notice of the Honorable Court had the counsel of the petitioner got the opportunity to draw the attention of the Honorable Court to the most relevant portion of the evidence of these three witnesses. The Honorable Court would have been fully convinced that the deceased Sanu Sarkar was a bona fide passenger. This is the point, my lord, because the dismissal was that he was not a bona fide. We failed to prove that he is not a bona fide passenger. So we have linked up the seizure of the railway journey ticket. we have narrated this, that about the case of Sangram Singh, and that that it is page 11. I have just Sangram Singh's para 17. The Honorable Court observed that next there must be ever present to the mind the fact that our laws of, my lord, my date of accident was 16/6. Sixteen six 2014. My lord. 16/6. I am reading from page 11, my lord. This is Sangram Singh's case, para 7. Next, there must be ever present to the mind the fact that our laws of procedure are grounded on a principle of natural justice, which requires that men should not be condemned unheard, that decisions should not be reached behind their back, that proceedings that affect their lives and property should not continue in their absence, and that they should not be precluded from participating in them. Of course, there must be exceptions, and where they are clearly defined, they must be given effect to. But taken by and large and subject to that proviso, our laws of procedure should be construed whenever that is reasonably possible in the light of that principle. In the case of collector land acquisition, Anantnag, in this case, I am reading the highlighted portion. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done because of a non-deliberate delay. Again, at 6, subsection 6, subpara 6, it must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. Power to entertain revision petition. Paras 14, 19, and 23 of the judgment of the Honorable Treasons Bench of the Supreme Court in S. Morrison Reddy versus Narayan Reddy. Para 14. In Colonel Avatar Singh II versus Union of Indian Others, 1980 Supplementary SCC 562, this court observed that a review of an earlier order cannot be done unless the court is satisfied that the material error which is manifest on the face of the order would result in miscarriage of justice or undermine its soundness. The observation made are as under. A review is not a routine procedure. Here we resolved to hear Sri Kapil at length to remove any feeling that the party has been hurt without being hurt. But we cannot review our earlier order unless satisfied that material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. In Shoshandra Kante and another versus Sheikh Habib. This honorable court observed, a review of a judgment is a serious step, and reluctant resort to it is proper.
only where a glaring omission or patent mistake or like grave error has crept in earlier by judicial fallibility. The present stage is not a virgin ground, but a review of an earlier order which has the normal feature of finality. Para 19. After discussing a series of decisions on review jurisdiction in Kamlesh Verma versus Mayawati and others, this court observed that review proceedings have to be strictly confined to the scope and ambit of order, such a ruling, as long as the point sought to be raised in the review application has already been dealt with and answered. Parties are not entitled to challenge the impugned judgment only because an alternative view is possible. The principle for exercising review jurisdiction were succinctly summarized in the caption case as above. Para 21. When the review will be maintainable. Subpara 2. Mistake or error apparent on the face of the record. When the review will not be maintainable. Review is not maintainable unless the material error manifests on the face of the record, undermines its soundness, or results in miscarriage of justice. Para 23, text, page 14. In Nagaraj and others, versus State of Karnataka and another, 1993 Supplementary 4, SCC 595, this court explained as to when a review jurisdiction could be treated as statutory or inherent and held thus. Justice is a virtue which transcends all barriers. Neither the rules of procedure nor technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone, even the law bends before justice. Mistake is accepted as valid reason to recall an order. Difference lies in the nature of mistake and scope of rectification depending on it, if it is of fact or law. But the root from which the power flows is the anxiety to avoid injustice. It is either statutory or inherent. The latter is available where the mistake is of the court. In Shivdev versus State of Punjab, at para 8 it was observed. The Honorable Supreme Court observed, it is sufficient to say that there is nothing in Article 226 of the Constitution of India to preclude a High Court from exercising the power of review which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave palpable errors committed by it. In Rajendra Kumar versus Rambhai, the Honorable Supreme Court on power of review of judgment observed at para 6. The first and foremost requirement of entertaining a review petition is that the order, the review of which is short, suffers from any error apparent on the face of record and permitting the order to stand will lead to failure of justice. In the absence of any error, finality attached to the judgment or order cannot be disturbed. The Honorable Supreme Court has discussed the power of the courts to review its judgment in Lily Thomas versus Union of India at para 52 as follows. It cannot be denied that justice is a virtue which transcends all barriers and the rules or procedures or technicalities of law, cannot stand in the way of administration of justice. Law has to bend before justice. If the court finds that the error pointed in the review petition was under a mistake and the earlier judgment would not have been passed but for erroneous assumption, which in fact did not exist, and its perpetration shall result in miscarriage of justice, nothing would preclude the court from rectifying the error.
It was further held at para 53. The court may also reopen its judgment if a manifest error has been done and it is necessary to pass an order to do full and effective justice. It was also held that the finality of the judgment delivered by the court will not be reconsidered except where a glaring omission or patent mistake or light grave error has crept in earlier by judicial fallibility. In Sochi versus Aravind Akshan Nayab, the Honorable Supreme Court referred at para 8 as such. In Parishan Devi versus Sumitra Devi, this court, after referring to Tungabhadra Industries, Meera Bhanja, Abhiram Tuleshwar Sharma, held at para 9. Under Order 47, Rule 1 CPC, a judgment may be open to review inter alia if there is a mistake or an error apparent on the face of the record. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise the power under Order 47, Rule 1 CPC. In exercise of the jurisdiction under Order 47, Rule 1 CPC, it is not permissible for an erroneous decision to be reheard or corrected. A review petition, it must be remembered, has a limited purpose and cannot be allowed to be an appeal in disguise. Hereafter, the Honorable Court observed at para 9 as such. The aforesaid authorities clearly spell out the nature, scope, and ambit of the power to be exercised. The error has to be self-evident, and it is not to be found out by a process of reasoning. We have adverted to the aforesaid aspects only to highlight the nature of the review proceedings.
Right, Puja Lord. Lord, before I advert to the facts of the case, my lord, I would just like to urge the legal points that are involved in this petition, my lord. Now, my lord, the judgment which your lordship had delivered, my lord, by that judgment, your lordship had dismissed the appeal both on the count of non-prosecution as well as on merits, my lord. Now, so far as the dismissal for non-prosecution is concerned, lordship may recall that order subject to your lordship's satisfaction, my lord. If the pleadings, those have been advanced in the review petition, if lordship thinks, my lord, those are sufficient grounds, lordship may recall that order dismissing the petition for non-prosecution. But so far as the judgment that has been rendered on merit, to review that, my lord, they will have to specifically urge the grounds that are available for reviewing a judgment. Number one, error apparent on the face of the records. And number two, my lord, discovery of new and important materials, those were missed earlier. Now, I'll come to that also, to the factual aspect, my lord. Now, if your lordship goes to the review petition, not a single ground that is available for reviewing a judgment has been pleaded, my lord. Without there being a pleading, whether your lordship, my lord, would entertain this review application, my lord. Not a single ground, my lord, has been pleaded for the single ground that is available for reviewing a judgment has been pleaded in the review petition, my lord. Now, coming to the facts of the case, my lord, the case that has been projected by my senior, my lord, may not be correct. If lordship comes to page 3 of the judgment, paragraph 3 of the judgment, everything is recorded out there. The judgment that is under review, my lord. it is a clear-cut case of, my lord, planted evidence and manipulation of the official, of the evidence, my lord. Those facts have been recorded in the judgment itself, that those aspects had not been placed before lordship, my lord. If I may read out paragraph 3, my lord, of the impugned judgment. In the second page of the judgment, I'm reading out, my lord. The appellant filed an application for restoration of the claim petition, which was dismissed for non-prosecution. The said application was registered as restoration petition number 5 of 2018. However, it appears from the order dated 12/11/2018 that the ground assigned for non-appearance in the claim petition was that due to illness of the wife of the learned counsel, steps were not taken. The learned tribunal, after appreciating the documents and the pleadings, arrived at the finding that the wife of the learned counsel for the appellant was discharged from hospital on 3/7/2018, and she was referred for follow-up on 27/2018 at Guwahati, and therefore the learned tribunal found that no material to show that the wife of the learned counsel was undergoing treatment on 18/7/2018. The learned tribunal, this is most relevant, my lord. The learned tribunal had summoned the IO, investigating officer, in connection with the said restoration petition number 5 of 2018, who had appeared along with the inquest report, and on being examined by the tribunal, the statement of the IO was recorded as follows. Now, these three paragraphs are most relevant, my lord. Everything will be disclosed, my lord, so far as the factual aspect is concerned. He deposes, my lord, I was posted at GRPS/Bongaigaon as ASI on 16/6/2014. I have investigated the case relating to death of Chanu Sarkar. I have investigated the death of the victim from the time of preparing inquest report till receipt of post-mortem examination report from the concerned hospital. I have prepared the inquest report, recorded statements of 3 to 4 witnesses during investigation. I had not found any article or material in possession of the deceased person. The accident had occurred about 50 feet away from the GRPS Bongaigaon office premises. I was sitting in the office GRPS Bongaigaon, and upon hearing hue and cry of the public, I immediately rushed to the spot and saw one person lying in injured condition, who was thereafter taken to the hospital by 108 ambulance. Station master had also visited the spot. One constable of the GRPS/Bongaigaon had accompanied the injured person since deceased to the Bongaigaon Civil Hospital. I had seen the injured person lying on the other side of the track, that is not on the side of the platform. Before I reached the hospital, relatives of the deceased had already arrived. I prepared the inquest report at the Bongaigaon Civil Hospital. I did not prepare any seizure list, as no material or article could be recovered from the possession of the deceased, even after thorough search of the deceased body. As no seizure list was prepared, there is no question of preparing Jimmanama. On further examination by the tribunal, after showing Exhibit A7, that is purported seizure list submitted by the applicant, the present deposing witness states as follows. The said document was not prepared by me. The handwriting and signature as appearing in the document are not mine. As stated earlier, no seizure list was prepared in connection with the case. I don't have the records of the case at this moment with me, but I have gone through the records. My lord, the handwriting, there were manipulation in the records, my lord. There were overwriting in the inquest report done by the subsequent officers, my lord. That is why these findings are relevant. Thereafter, on further examination by the tribunal, after showing Exhibit 4, that is the inquest report submitted by the applicant, the present deposing witness states as follows. Yes, I have prepared the said report, and signature appearing in the document is mine. Accordingly, the learned tribunal arrived at the finding that the document filed with the claim petition were not prepared by the IO, and the seizure list appended to the claim petition was not also prepared by him. Even assuming, my lord, that the ticket was handed over by the person concerned, whether it's a valid seizure, my lord, whether the tribunal would be bound by production of the document by a private person, my lord, when it is not done officially. And the records clearly show, my lord, the investigating officer, he was present right from the beginning till the time of preparing the postmortem report. he specifically stated deposed before the tribunal saying that nothing was recovered. So no Jimmanama was prepared, my lord. And so far as the legal question is concerned, my lord, whether in the absence of any pleading, absence of any ground advanced by the other side, my lord, whether your lordship would like to review the judgment, my lord. Because the grounds for reviewing a judgment are specific, my lord. Either they will have to show that there has been an error apparent on the face of the record, or discovery of some new and important material that was missed at the time of filing the petition, my lord. Nothing has been pleaded in the review petition. Under such circumstance, my lord, it's my humble submission that this review application, my lord, will not be entertained, my lord, and the judgment which was rendered by your lordship doesn't require interference. That's my submission.
Permitted to just submit one clear addition. This seizure is my lord. The IO was not along. My learned friend is telling that IO was all along. IO was not there. After he sent this injured to hospital, and after the family members arrived, the deceased was sent for postmortem report. Till that time, IO was not there. So whenever he was sent to the postmortem hall, the items in his possession was given by the constable, who it is on record. Constable was deputed to take this injured to the hospital. He delivered it to Sanu Sarkar, Benu Sarkar. So how it came to the hand of Benu Sarkar, it has been very clearly, my lord, linked up. And I basically submit, my lord, one thing. 41, in the record, there is seizure list. It is surprising how the IO is prevaricating from the report. This report he was prepared, yeah, maybe. I have got some experience in this regard. What happened? IO gets this written by somebody else, that maybe his signature is there, other signature also there in other papers also. There cannot be any doubt that IO has put the signature as IO, Rabindranath Ray. And very surprisingly, my lord, before the signature of the IO, inspector inserts in the certificate, inspector inserts has certified to be true copy. This seizure list was produced from custody of the police station. It was produced by SI Jangeshwar Pathak, and it cannot be expected any other person can have access to it. If any person could have access to it, still could have been doubted had there been no certification by officer himself. The seizure list has been very rightly certified to be true copy by the, so once the officer in charge has certified, it is a matter of record. And otherwise also, this IO, for some reason, he may have belied it. I have supported that once he belied the record, matter of record, it is not possible for others to go and interpolate it. If it was like this, they could have investigated the matter properly. If somebody has interpolated it, and person is dead, record justifies, record shows that there was seizure of ticket, and it was from Guwahati to Sautara, everything is all right. It is stated in Kurupana. I am taking your lordship to page 7 of my submission. A hostile witness, para 18, my lord. Page 7, para case of Kurupana, favor. A hostile witness may not be rejected outright, but the court has at least to be aware that prima facie, a witness who makes different statements at different times has no regard for truth. The court should therefore be slow to act upon the testimony of such a witness, and normally it should look for corroboration to his evidence. Here, in this case, the availability of the seizure list has been fully corroborated by the entries made in the case diary, as well as by SI Jangeshwar Pathak. Moreover, the inspector in charge Bongaigaon GRPS on 38-2014 have who recorded below the signature of the seizing officer ASI Rabindranath Esat, certified to be true copy, leaves no scope for doubt about this seizure. My lord, it is a matter of record. One sub-inspector has deposed that it is from case diary, it is a part of the case diary. And inspector in charge has also authenticated the seizure list. He cannot, therefore, my lord, there is no scope of doubting it, or he may be. For some reason, the IO may prevaricate it, but there are supporting materials, supporting evidence that the seizure was made, the seizure list is there. The SI Jangeshwar Pathak has found it in the case diary. It's a part of the case diary, so there is no question of discarding it. May it please your lordship may consider all this importance for you.
Just if I may just reply, at that point of time, gone through the records, my lord, of the case, my lord. What transpired from the record was that the person who had deposed before the tribunal, the IO, he had prepared the report. Later on, he was transferred out to some other place, and subsequently, in that report which he had prepared, my lord, there was overwriting, my lord. Overwriting, and many things were incorporated which were not in his own signature. That is what he has stated in his statement, in his deposition. And what is certified by the subsequent officer is what was there in the document, including the manipulated handwriting, my lord. Anyway, my lord, that is not the issue. Main issue is whether the grounds of reviewing a judgment have been pleaded and materials have been advanced, my lord, to sustain those grounds, my lord. That is the main issue, my lord. Not a single ground for reviewing a judgment has been pleaded in the review petition. That's all, my lord. Standing counsel. And a free. Mansur.
After vacation, my lord.
There's no hurry, my lord.
New Year, my lord.
Lordship can take sufficient time.
Sufficient, my lord. Because court is also very much busy now these days. Ending year, my lord, court is also very much busy for different matters, administrative as well as judicial. Yes, sir.
Yes.